Hello and welcome to Child Protection 101 session number 6. You might wonder why I'm sitting here in a courtroom doing this particular presentation while all of the others were done to a live audience. Fear not, this presentation has been done previously to a live audience, but once I got home and I was downloading the footage, I discovered that something was awry with the audio. There was some interference with the wireless system that caused it to be this screaming high pitch that would have driven us all crazy if we'd had to be exposed to more than 2 or 3 seconds. So this is a do-over. Today in session number 6, we're here to discuss case plan hearings, review hearings, and status hearings. The good news of getting to do a redo in this case is that from the time I actually did the initial presentation to the time of today, there has been a statutory change that has dramatically changed a bunch of the information. So I'm actually pleased to be able to do a more up-to-date version stating the law as it is now. To recap where we are in a child protection case, if you've watched the previous presentations, you'll know that we've initiated a child protection case, we've had a shelter care hearing, and then we have had, within 30 days, an adjudicatory hearing to determine 2 things. 1, whether there is jurisdiction for the court and the case to continue, and 2, if so, if the case is moving forward, what the disposition is. Where should the children be while we work with this family? And again, the court has 2 choices. 1 is either legal custody with the Department of Health and Welfare, meaning that the children would remain in foster care, or be back home with the parents on what's called protective supervision. If we have gotten past the adjudicatory hearing and this case is continuing, then we move forward to our first topic of the day, which is case plans. Case plans are described in Idaho Code 16-1621, and they are to be held within 30 days of the adjudicatory hearing. Most commonly, if a case is on track, we will have had our adjudicatory hearing by 30 days, which means that we will be having our case plan hearing at the 2-month mark, or 60 days. But if it is a case that's had a contested adjudicatory hearing that requires us to set it out numerous times to get that accomplished, it may well be that the case plan will not be at 60 days, but whenever we finish the adjudicatory hearing in 30 days after that. The purpose of a case plan hearing is for the court to determine whether it is in the best interest to approve, reject, or modify the case plan that has been prepared by the Department of Health and Welfare. And as far as reports for this type of hearing, the case plan itself has to be prepared by the Department of Health and Welfare and filed with the court no later than 5 days prior to the hearing, and copies of this case plan delivered to all parties. And that, of course, is very important so that the parents for whom the case plan is going to be ordered have the opportunity to speak with their attorneys, go through the case plan, and come to the hearing prepared to ask for modifications, changes, or to agree to the order. At the hearing itself, the following folks need to be present: the prosecutor or the attorney general, the Department of Health and Welfare social worker, the parents, of course, and their attorneys. The guardian ad litem will be present, or if there is a child's attorney because the child is 12 and older, then that attorney will be present. The guardian ad litem attorney will be there for the guardian. The foster parents certainly have a right to be present and to be heard. Whether or not they're allowed to remain for the full hearing is up to the parties and up to the court. And similarly, the children should be present for the case plan hearing. Again, they have a right to be heard. Whether or not they remain for the entirety of the hearing will be up to the parties. That case plan, per the statute, has to include a wealth of information. If you feel at some point intellectually curious, you can pull up on the internet 16-1621, and you can read through all of the various matters that need to be addressed in a case plan. It's quite extensive. It's about 3 or 4 pages long, single-spaced. And I'm not going to go through every single excruciating detail, but understand that there is a wealth of issues and matters that we are to address in a case plan. But first and foremost, a case plan needs to include what's called a reunification plan. Anytime we have kids come into care, the first plan, the default plan, what we're always working toward, is reunification. And so that needs to be reflected in the case plan. And that reunification plan needs to be a list of the reasonable efforts that the Department of Health and Welfare is going to provide and that the parents are going to engage in to make it possible for the child to return home. So that reunification portion of the case plan needs to identify the issues that need to be addressed before the child can be returned safely home. Examples of that, of course, would be that if the case began because the parent is incarcerated, they'll have to resolve their incarceration. The case began because of the parent's engagement substance use disorder, they're going to have to address that and demonstrate sobriety. If lack of housing contributed to the removal, if there are mental health issues at play, the department is going to do their assessment and they will list in the case plan all of the issues that need to be addressed. Then the next part of the reunification plan are the tasks that the case plan for the parents of what they need to do to reunify with their children. And the tasks in case plans are marked very clearly. They're usually in bold or underlined, and they specifically are numbered to say, here's the things that a parent needs to do for their children to return. And when appropriate, the case plan needs to identify terms for visitation, supervision of visitation, and child support. I want to digress briefly that this is the one time and the one time only in a child protection case where the court actually has some authority over visitation. Beyond this and the case plan hearing, once the department is granted legal custody of a child, they have the authority to determine who the child sees, who the child visits with. They are vested with that authority and the court is not to interfere in it. But at the case plan hearing, and because of this statute, the court does have the authority in the case plan to address visitation, to specify that there will be a minimum level of visitation, could also address the terms of the visitation. And so for the parent attorneys who might be watching this, I would encourage you to note that this is the one time the court can weigh in and can require the department to offer certain levels of visitation. It's not often done. It's not often a debate that we have in the hearings, at least in my experience, but it is something that is possible. The case plan, in addition to the reunification plan, needs to contain a number of items that are identifying the services for the child. These services can include meeting the child's educational, emotional, physical, and developmental needs, and assisting with the child in adjusting to their foster placement. There are services needed to be identified to ensure the stability of the placement. Ideally, a child comes into foster care, is placed in one foster home, and stays in that foster home until they return back to their parents or to whatever alternate permanency occurs. And these children, of course, have been exposed to a great deal of trauma. That trauma reflects in behaviors, and these children can be very challenging for foster parents to manage and care for long term. But we should be identifying and helping foster parents to prop them up to the best of our abilities such that children can, if possible, remain in the same placement for the entirety of the case. And that can be addressed in the case plan. For youth who are 14 years or older, there is a whole list of areas that are to be addressed in a case plan, including identifying services for a transition to successful adulthood. That is a more recent phrase, as in the last 2 or 3 or 4 years from the federal government. I think that it has been commonly known as independent living skills, getting children ready for their 18th birthday so that when they make that transition from childhood to 18, if they are not going to take advantage of extended foster care, if they're not home with their parents, if they're not in a guardianship, if they're not adopted, that they have all the skills, or at least some skills, to survive as they make that transition. And the case plan is to note that the child has received something called the Youth Bill of Rights. The case plan is also to address options to maintain the child's connection to community. This is recognizing that when we remove a child from their family of origin, it's incredibly disruptive to their life. Oftentimes it means a change in their school, it means a change in their church community, it means a change from their neighborhood and all of their friends. And not only are they losing immediately living with their family, but they're also being disconnected from everything that they are familiar with. And in recognition of that, the case plan is supposed to identify ways that we make that transition and that separation less harsh. And so, the case plan is supposed to identify individuals with a significant relationship to the child, plus organizations or community activities with which the child has a significant connection. Catching on that the child has been playing soccer for 3 years and they're very connected to their soccer coach and very connected to their soccer team, and making ways for us to be able to maintain that connection. The case plan is to ensure that there is, to the extent possible, educational stability for the child. I've already mentioned that there's often disruption in the schools for these children, and you hear these heartbreaking stories of kids, over the course of their time in foster care, moving from school to school to school, and every time they move, they lose certainly a lot of educational progress, but their records don't keep up to them, and if they're in older years and they're high school age, then they're losing credits, and trying to gather up all those information to make sure they get their diploma can be very challenging. Needs to include a visitation plan, and again, this is one of those times that the court can weigh in and specify a visitation. And finally, the case plan is to document that the siblings have been placed together, and if not, the efforts that have been made to place the siblings together, and if they are not placed together, what plan there is in place to ensure frequent sibling visitation. Brief tangent here, in that when you have the opportunity, if you do have the opportunity to hear former foster youth speak in a panel-like setting, in all of the panels that I've seen of former foster youth, universally the one area that they have stated that they are most resentful about their foster care experience was not being removed from their parents. They usually can identify why that needed to happen, but they are very upset, and understandably so, that they've been removed from their siblings, if indeed they were. And in many cases, if you've got a large sibling group or even a small sibling group, but one child has some pretty significant behavioral issues and they can't find a home for all 2 or 3, the kids are split up. And that is a major trauma and something that really sticks with these youth even into their adulthood, saying, I understand why you took me from my parents, but why did you take me from my brothers and sisters? We can never really have a very good answer for that. And if that is the case, if they're not placed with their siblings, then it needs to be explained in the case plan what we're doing to maintain that connection. The case plan will also include a concurrent plan. So every time we have a child come into care, we have a primary plan. It's always reunification, but there's also an obligation to be working a plan B, an alternate plan, a concurrent plan. What happens if we cannot reunify? What happens next? And the idea here is that instead of waiting until 12 months to start thinking about a plan B, that we're thinking about that plan B from day one, sort of quietly on the back burner, in the background, so that if we need it, we can bring it to the fore and move quickly on that, so we're not leaving kids in foster care for days longer than necessary. So that concurrent planning is supposed to address all options for permanency, including in-state and out-of-state. It's supposed to address the advantages and disadvantages of each of these proposed placements with relatives in-state and out-of-state. Specifically identify the actions necessary to implement the concurrent plan, and specifically set forth a schedule for accomplishing the actions. Now, I will tell you that by the time we get to the 2-month mark of a case and all of the whirlwind of doing these cases and all the investigation, this is the one area where the department most struggles. So you're not likely going to see this actually put into practice in actual real-world case plans. As a judge, I don't make too big of an issue of it. This is a pretty heavy ask to not only get a parent and their family and kids, get them situated, get them stabilized, get them started on all their services, and all the while, in all their Department of Health and Welfare's social workers' spare time, to be doing a very thorough investigation on the 6 out-of-state relatives, identifying the pros and cons of each, and detailing what you're going to do to try and get to Aunt Susie or Uncle Joe in another state. So I say it's aspirational. The department does put work into this, but to the detail as called for in a case plan, you're not going to see that. When you get a case plan, you're going to get not one, but 2 documents, and they conveniently label them Part 1 and Part 2. Part 1 addresses the parents. So everything that we've discussed as far as a reunification plan, the tasks, and then the concurrent planning, all of those issues are going to be addressed in Part 1. Part 2 is addressing all of the children and all of the issues that we've just discussed and all of the things that need to be in there. So typically when I get a case plan for a family, the Part 1 is going to roughly be 4 to 5 pages, and the Part 2 is going to be close to 15 pages. And so collectively, Part 1 and Part 2 make up the entire case plan, and they do address all of the issues that are identified in 1616-21. Now, at a case plan hearing, at least in Ada County, we're going to focus largely on Part 1, the tasks that the parents have to accomplish, and we're not going to go through with a fine-tooth comb Part 2 and all of the issues regarding the children. That is not to say that as a guardian ad litem, you shouldn't be reading the Part 2 with great interest, and if there is any issues in there, if there's any additional services that you think would benefit the children based on your own independent investigation, do not hesitate to raise that issue at a case plan hearing, because the hearing, while they almost always just focus on Part 1, are also encompassing Part 2, and those are legitimate areas of discussion. Common case plan tasks, speaking of the Part 1, it is a common lament of mine that I wish our case plans were a little bit more specifically tailored to each family, reflecting that there had been a lot of time put in sitting down with the parents and their extended family and some critical thinking putting into what the case plan should be. The reality is that many of our case plans look more or less the same, and I can kind of recite for you what's going to be in most case plans, and here they are. The first task is going to be to obtain and maintain housing. Makes sense. We need them to have a home where they can have the children. Second is for them to obtain and maintain a legitimate source of income. That also makes sense. They need the ability to legitimately provide financially for their children. Now, legitimate income is specifically chosen. There are some families, some parents, who cannot get employment, but they do qualify for Social Security disability, and if they do, that is a legitimate form of income. My favorite story was that I had a family many years ago where the father was a professional gambler, and there was some question raised by the department whether that was legitimate income, and the answer to that was yes. He would go down to Jackpot or Las Vegas or Reno and was a very successful professional gambler and poker player, and was able to make 6 figures regularly every year in Nevada, where it is perfectly legal to do that, and that was the basis of the family's income, and that was good enough for me. A third task that's almost always in there, given the clientele that we're working with, would be to do a substance abuse evaluation and follow the recommendations. Almost always we ask for a mental health assessment of the parents and for them to follow those recommendations. They will almost always, they being the department, always request that the parents engage in some form of parenting education. Depending on the age of the child, depending on the circumstances, they will tailor which parenting education course they request for the parents. And they will always include a task that says that the parents will attend all of their visits with their children and attend all medical, counseling, and educational appointments. In essence, telling them you need to continue being as close to a full-time parent, engaged with your children, and aware of their lives as you can. Now we're going to talk about the next hearing after we get through a case plan hearing. It is possible under the statute that from the 2-month mark of the case plan hearing to this next hearing, which is the 6-month review hearing, that there will be no court hearings. It is quite possible, and I would recommend that between the 2-month mark and the 6-month mark, that there be something called the status hearing, in which the parties gather together, the court gets an update as to how the parents are doing, the children are doing, etc. But that is up to the discretion of the court. What is statutorily required is the next hearing is called a 6-month review. Now, effective July 1st, 2025, a new statute came into place, 161622, that requires the court to set a 6-month review hearing, and then following that, a subsequent 2-month review hearing every 2 months until the case is closed. So now the requirement is that we have a hearing at 6 months. We're still calling that a 6-month review. That's primarily because that type of review hearing is called for by the federal government and is very important for funding. So we need to make sure we conduct that hearing and that it is labeled in a way that our federal partners recognize. And then after that 6-month review hearing, there'll be these subsequent 2-month reviews. But everything now has just really been called a review hearing. So the big change in this is now it is review hearings as opposed to 6-month review statuses or permanencies. So the timing of a review hearing is at 6 months, if we've been 6 months into the case, and then every 2 months after, so 8 months, 10 months. Then we're going to have a 12-month hearing, which we'll talk about in a future session. That's called a permanency hearing. That's also going to be labeled a subsequent 2-month review or a subsequent 6-month review. Those happen at the same time. So now we have these review hearings, and those are 6 months, 8 months, 10 months, 12 months, 14 months, 16 months, 18 months, however long the case needs to go forward. For all of these reports from the 6-month review on, the department and the guardian shall file a report that must be with the court no later than 5 days prior to the review hearing. And these are informal hearings, meaning that the Idaho rules of evidence do not apply. And that is critical because the information coming from the department, information coming from the guardian ad litems, it's all hearsay. It's all information that you have learned from other sources, doctors, counselors, teachers, foster parents, the children themselves. It's all out of state, out of court. It's all out of court. It's all out of court information that you are gathering and putting into these reports. And unless these were informal hearings where the rules don't apply, then there would be no way for the court to consider this or to use that information. So it is very important that these are informal hearings where the rules don't apply. At these review hearings, the usual suspects need to be present. We need the prosecutor or the attorney general. We need the department social worker. We need the parents. We need their attorneys. We need the guardian ad litem or the child's attorney if they're over the age of 12. If there is a guardian ad litem, they need to have their attorney present. The foster parents need to be present and have a right to be heard, and the children need to be present and have a right to be heard. And again, both foster parents and the children may be excused if the parties object to their ongoing presence. The purpose writ large of review hearings is many. And again, 161622 goes on for 3 or 4 pages and specifies many, many areas that the court is to address. And at least in Ada County, we endeavor to do our best, but clearly we don't get to everything that is marked in the statute. But here is in general terms what we're supposed to be talking about. First and foremost, the hearing is for the court to determine the safety of the child. Safety of the child is always paramount. It's always what we're focused on. Second thing that we're focusing on is the continuing need for the placement. I want to let that sink in. The idea of these hearings is always to be asking, first, is the child safe? But two, does this case need to continue? Do these kids still need to be in foster care? Because I hope we all agree that it is not healthy, it is not positive, it's not good for kids to languish in foster care. And so getting them to a resolution of the case should always be forefront in our mind. And so these hearings are an opportunity to talk about that. Does this case need to keep these kids in foster care, or is it possible for them to go home? Third area that we're looking at is the extent of compliance by the parents on their case plan. And I'll say from my experience, that tends to be the bulk of what we discuss in these review hearings, is what the parents have or have not done on the case plan, which of course goes hand in hand with whether we're able to have the children return. The fourth area that we're looking at is the extent of progress that's been made toward mitigating the causes that necessitated placement in foster care. Also goes hand in hand with progress on the case plan. How are they doing toward getting to a safe and stable place? And if we have not determined and figured out the Indian Child Welfare Act applicability by the 6-month review, I'll say we're doing something wrong. But there are some cases where it is raised and the exploration does take a while to hear back from the tribes whether or not it applies. But definitely that's something that should be front-loaded and looked at early in the case and determined quickly. But if it's still not resolved, it definitely needs to be addressed at these review hearings. The next purpose of the review hearing is to inquire about the child's educational stability. I've already discussed the need for doing that. We're supposed to follow up to ensure that we are keeping the kids in place. Next one is to inquire about the sibling placement. Again, I've already spoken to that issue. We're supposed to be reviewing it to make sure that we are adhering to prioritizing sibling placement. The next purpose is to inquire about permanency. For youth 12 and older, they are to be asked specifically by the court and the guardian ad litem what their wishes are. And for youth who are 14 years and older, the court should review the services that are being offered to these children, the independent living skills, the services for a successful transition to young adulthood. We're supposed to be discussing all of those. The next purpose of a review hearing is to document the efforts related to the reasonable and prudent parent standard. A brief digression there. Been doing this now long enough that I can remember when this came in. Essentially, the restraints on foster parents up until 4, 5, 6 years ago were really severe, and foster children were not allowed to be kids in the way that non-foster kids are allowed to be kids, meaning that anything that had the whiff of danger was to be prohibited to children. They weren't supposed to be getting on four-wheelers. They weren't supposed to be riding horses. They weren't supposed to be handling firearms and going hunting. Even going out on a boat and going fishing was a little bit suspect. So there were a variety of rules that said thou shalt not expose this child, foster child, to any unnecessary danger. And of course, that really put a damper on the foster parents and their lives and their activities with their own children. It certainly deprived our foster youth of being able to participate in normal childhood activities. And so the law was passed that allows foster parents now to exercise what's called a reasonable and prudent parent standard. It's no longer a list of thou shalt nots, it's more now a list of, is it reasonable and prudent for this foster parent to offer this kind of activity to the foster child? If they would offer that same kind of activity to their own child and they're doing so responsibly, then foster children should have the right to engage in that same kind of activity. And so we are to discuss that. I'll be honest, this doesn't come up much in our review hearings. Once in a blue moon, someone may raise an issue and say a child's not being allowed to do some activity, and we can address that. If we have a youth who is 16 years or older and that permanency goal has been approved of APLA, another permanent planned living arrangement, there is an exhaustive list of things that we're to be discussing regarding that child. I won't go through those in detail here. Another area in this review hearing is that we are to be documenting and inquiring regarding psychotropic medication. It is a sad reality for some youth in foster care that they will have a mental health condition that requires the assistance of medication. The issue is that a lot of times as kids are bouncing from foster home to foster home, there's no real continuity of care, and in the bad old days, these children would sometimes keep getting just prescription after prescription, and they would have 7 or 8 different psychotropic medications, some of which were contraindicated, and it was having some pretty catastrophic results. So the federal government, in their wisdom, stepped in and said, look, we need to make sure the courts are reviewing the issuance of psychotropic medications to kids. What this looks like in practice is that the department needs to list in their report all the medications a child is taking, when the child was last seen by a psychiatrist or a medication manager, and let us be being vigilant to make sure that the medications a child is receiving are recommended by a recent evaluation, not just a historic, well, 3 or 4 years ago it got prescribed and we've just been blindly keeping the child on the medication without any review. So that is something that needs to be discussed. Again, isn't typically talked about in the actual hearings that, in my experience, but it is certainly in the reports. It's certainly something that I review. As the guardian, you will, of course, be reading that portion. If you have any concerns, you can raise it in the hearing. And the final area of purpose of a review hearing is to project, when reasonable, a likely date by which the child may be safely returned and maintained in the home or other permanent placement. So again, we're always thinking about what comes next. What can we do to get this child to their next stage, ideally back with their parents? If so, when do we think that might happen? If not, what are our alternatives? Let's start looking at that concurrent plan seriously so that we can start taking steps toward that. And so that is all of the areas that I wanted to discuss regarding a review hearing. And again, we're going to be talking about all of these areas and addressing all of these now at 6 months, now at 8 months, 10 months, 12 months, 14 months. And the big change for both the department and the guardian, not only are there more frequent hearings, but there are more frequent reports. So this statutory change and this change to every 2 months, again, after the 6 months, does require a fair amount of additional paperwork and report writing for the guardian and the department. Final thing that I wanted to discuss is that contained in 1621 or 22 is the ability for a court to hold what are called status hearings. And a status hearing is exactly what the name implies. It is a hearing called by the court just to review the status of certain areas. In this instance, it is not an exhaustive review of everything that is set forth in a review hearing. It can be a very targeted, we're just here to talk about this one specific area. And in status hearings, there is no requirement for any reports to be filed by either the department or the guardian unless the court specifies in advance that they do expect a report. Prior to the statutory change, I would always hold status hearings every 2 months. So the statutory change has not really modified the practice here in Ada County much as far as the frequency of hearings. I've always believed that the more frequently you can conduct hearings, the better outcomes you have for children, better outcomes for their family. So I've been advocating for a long time to do status hearings and have done so. The main change, of course, is now that they are review hearings, there is the report requirement, so it's some additional work. But still, even with the new statute requiring review hearings every 2 months, this statute remains in place. So you may have a judge who will want to do a status hearing even between the mandatory 2-month review hearings. If you need to come back in a month because there's a particular pressing issue, or come back in a couple of weeks because there's a really pressing issue, the court always has the ability to call a status hearing and summon the parties to court in person or online. And I would remind guardian ad litems that you are parties to the case, so if there is some urgent issue that does come up, you have the ability through counsel to request a status hearing and ask the parties come together in front of the court and hash out whatever the issue is. So a status hearing can be called by any party through their attorney through the proper motions. And with that, I have covered case plans, review hearings, and status hearings, and I thank you very much.